And so we are very honored to have you on our beautiful, restored, completely restored campus. Now, you may have also seen some other construction, but that's not related to the tornado. It's just that William Carey continues to grow. And so the construction that you saw next to this building is a new 3-story student center that will be going up and will be completed by about December of 2020. Several months ago, we were contacted by the Mississippi Gulf Coast Federalist Society about the possibility of hosting this forum for our candidates for Mississippi Attorney General. And we were eager to seize this opportunity because we believe as a university, we take both Christian seriously and university seriously, and we believe that means providing opportunities for our students to be able to engage in real issues, to be able to hear from candidates in their own voices, unfiltered, and to be able to learn to think critically and to analyze the ideas that they hear and to process those ideas. And so being able to co-host a forum like this is very much a part of what William Carey University is about. We certainly are committed to our students having these kinds of opportunities. This forum would not have been possible if not for Russell Nobile and Jane Minardi, who have really spearheaded this and have been a major part of making tonight possible. I also want to express our concern for Judge Charles Pickering, who was planning to be the moderator, but he became ill, and so Russell will be moderating the forum this evening. I also want to recognize our public officials. I know that we have a number of public officials that are here tonight, and I know that some will even be coming in a little bit later. I know that Deborah Delgado, councilwoman from Ward 2 for Hattiesburg, Representative Kent McCarty, representative from District 101, and Pamela Castle, Forest County prosecutor. I know that they are here. Do we have other public officials that are here? If you are here, if you will raise your hand or stand, we'd like to recognize you and thank you for your service. I certainly want to thank our public officials. I will open us in a prayer, and then I will turn it over to Russell, who will then introduce the candidates, and then will lead us in the forum. And then I would like to, before I pray, would like to invite all of you after the forum to come to our recital hall. Just as we go outside here, go outside the glass doors, and immediately to the right, before you have to get in any kind of rain, immediately to the right is a recital hall. And we have a reception there. We have some food there and some drinks there for you, and all of you are invited. Let us go to the Lord in prayer. Dear Heavenly Father, God, I thank you for this great state of Mississippi. And God, I thank you for its public servants who indeed serve its citizens and the state. God, I thank you for these candidates, and I thank you for their desire and willingness to serve this great state. God, we pray for wisdom and discernment as we hear from these candidates and we hear their ideas and we learn of their experience for this very important office in this state. God, I thank you for your blessings. I thank you for your faithfulness in all times of our lives. And God, I thank you for William Carey University that prepares students for good citizenship, to be engaged with society, for service, for careers, and for academic rigor. We pray that you be glorified in all that we do, say, and think. We ask this thing in the name of Jesus. Amen. Russell.
Good evening. On behalf of the steering committee of the Federalist Society's Mississippi Gulf Coast chapter, I'd like to welcome you to the 2019 Mississippi Attorney General Candidate Forum. I'm Russell Nobile, and along with Jane Maynard, co-founded the Mississippi Gulf Coast chapter of the Federalist Society. The Federalist Society's main goal is to promote fair and open debate on the importance of individual freedom, the role of courts in interpreting statutes and the Constitution, the state's role in preserving freedom, and separation of powers. To be clear, the Federalist Society is a nonprofit, nonpartisan 501c3. It neither endorses any candidate nor will ever take a legal position in court filings or in any other filings. Tonight, you are part of a long-standing American tradition in which candidates come together to debate and discuss complex topics and submit working principles to the collective judgment and wisdom of voters. For the first time since 2003, Mississippi will elect a new Attorney General. Mississippians need to see from their Attorney General candidates and have them face one another as they discuss the hard and complex issues that their chief law enforcement officer of the state will face. These candidates, through their participation in this forum, are ensuring that Mississippians are provided the essential aspect of fair and open elections. Before I introduce the candidates, however, I'd like to express our great appreciation for our partner, William Carey University. Dr. Hummel, Dr. King, along with the staff, the students, and the faculty have gone truly above and beyond what we could have ever expected. We've been pleased and greatly appreciate their hard work in organizing this event and hosting this forum. Many of the questions that you'll hear tonight presented to the candidates actually came from William and Carey students directly, who will, of course, will be the future leaders of the state of Mississippi and the region. I would also like to thank Judge Pickering, who, as Dr. Hummel mentioned, is unable to participate. However, his help in planning and organizing the moderation of this event is essential. Judge Pickering dedicated his career to public service and promoting the rule of law in Mississippi. He's retired now from the bench, but he clearly remains dedicated to these principles. We've greatly enjoyed working with him, and we're truly honored by his participation in this event, even if he's not here right now. A brief overview of tonight's format. The candidates have heard some of this, but I want to make sure everyone else knows it. There will be an opening and closing statements. After the opening, I will present each candidate with a series of 8 pre-selected questions. Each candidate will get 3 minutes to answer. I may ask for some follow-up questions. I may ask follow-up questions as needed. We'll do our best to track time to make sure everyone gets an equal opportunity and equal time to discuss it. The questions that were ultimately selected all came from William Carey students, Judge Pickering, and the Federalist Society chapter members. Candidates do not know the final topics that were selected for this. However, they were giving a list of topics that we would consider several weeks ago for them to formulate their positions on. This event is being recorded, and it will be available on William Carey and the Federalist Society's web pages and social media platforms shortly after the event. After the panel's introduction, I ask that you all hold applause until the conclusion of the event, and if you haven't had a chance to now, please silence your cell phones. I would also like to thank our 2 candidates that have come here, Representative Mark Baker and Andy Taggart, for taking time out of their busy campaign schedules to help us preserve this great American tradition of coming and speaking directly to voters. Both have been easy to work with and are clearly committed public servants. Their participation tonight is an indispensable service to the promotion of public discourse in the state of Mississippi. All 4 Attorney General candidates in the state were invited. Democrat Jennifer Riley Collins early on declined to participate. We actually rescheduled this event from our preferred date before the end of the school year at the request of Treasurer Lynn Fitch's campaign, and are disappointed that she has chosen not to come after she confirmed the date and we publicly announced the event. Nevertheless, we are very excited to be able to provide the public with an opportunity to examine and learn more about candidates Baker and Taggart, and look forward to an interesting discussion tonight. Representative Baker, who's on the far end, is a graduate of the University of Memphis and the Mississippi College School of Law. Since 2004, he's represented District 74 in the Mississippi House of Representatives. I believe 74 is all in Rankin County, is it? It is now. Previously, it covered parts of Madison County, I believe.
That's correct.
He is chairman of the House Judiciary en banc and Judiciary A committees, and he's a member of the Ways and Means, Banking and Finance, Transportation, and Investigative committees. He's a former city prosecutor and a municipal judge, and he is currently in private practice in Brandon. Sitting next to Mr. Baker is Andy Taggart. Mr. Taggart is a graduate of Mississippi College and Tulane University School of Law. He formerly served as Chief of Staff to Governor Kirk Fordyce. He was elected previously to the Madison County Board of Supervisors, where he served some part of his term as the board president. Andy has also served as litigation counsel to Governor Barbour and as auditor counsel for the state auditor's office when Phil Bryant was previously in that position. He was appointed as co-chairman of the Mississippi Department of Corrections Task Force by Governor Bryant recently. Currently, Mr. Taggart is in private practice in Ridgeland. All right, let me change roles here. Good evening.
Good evening.
All right, y'all have got the schedule first, and so I think we'll start with our opening statements. Mr. Baker, you're first.
Sure. Good evening. Thank you so much for having me. I'm Mark Baker. I'm from Rankin County, as you heard. I want to introduce my wife, Lady, who's in the audience. We've been married for 30 years. She's a school teacher at Brandon High School, so I'm sure that I'm going to have to check my grammar tonight. Seated next to her is my mom. Thank you for being here. And my son is over here. Chase is a senior public policy major at Ole Miss. I practiced law for 32 years actively in Brandon. During that time, I've tried cases in federal and state courts all over the state. I've had appeals in state and federal courts as well. I've served as a prosecutor and a judge, and I've been in the legislature for the last 16 years. As part of my practice in Brandon for the last 25 years, I've actively represented governmental entities, the city of Brandon, the town of Puckett, some water associations, and things like that. Proud of my service in the legislature for the last 16 years, the last 8 of which as chairman of the Judiciary A Committee. When I was first elected to the legislature in 2004, we were in the minority, and now we're in the majority. I'm going to talk to you a little bit about that tonight as chairman of Judge A and what we did to get the majority and why that role as Republican leader from 2007 to 2011 suits me to be your next Attorney General. Thank you very much.
Hi, my name's Andy Taggart. It's my privilege to be here and to offer myself as a candidate for Attorney General. My bride, Karen, is about 4 rows down from the back, and if we make January 8th, we will have been married for 37 years. William Carey, as many of you know, was a very early Baptist missionary, the person for whom this university was named, and he is quoted as having said to his colleagues when he felt the call of God to go serve as a missionary, "If you will hold the ropes, I will go down into India." By which he meant that he was willing to take the vanguard, to take the lead, so long as he was confident that there was support back home who would make it possible for him to eat, basically. And that really is what happens every time somebody offers himself or herself for public office. It really is a message to the rest of the community. If you will continue to make sure that the community can be healthy and the economy can wobble along, then we will offer ourselves to serve for some period of time, which is exactly the model that the founders originally intended. My colleague, Chairman Mark Baker, has served honorably and well, and it's been a pleasure to come to know him over the years that he's been in the legislature. And people who offer for the legislature particularly are making a sacrifice because they are sort of expected to be working full-time, even though the legislative session is typically 3 to 4 months during the year, while they're also trying to keep their businesses, or in his case, their law practice alive. I believe I'm best suited to serve in this office for 2 key reasons. The chief law enforcement official of the state ought to be focusing the resources of his or her office on what I believe to be the gravest danger faced by our state, which I believe to be the scourge of drugs. And secondly, the chief law officer of the state, which is the Attorney General also, ought to be a practicing lawyer who has developed his or her courtroom skills and law practice chops in the real live active practice of law, not just someone who has a law degree. If we make June the 19th, over the last 24 months, I will have argued twice before the Mississippi Supreme Court, once before the Court of Appeals, and once before our federal district court, and I believe that distinguishes me from the other candidates in the race.
All right. Our first question of the evening starts with Mr. Taggart. This comes from a William Carey student, and it is, what experience, personal and professional, do you cite that best qualifies you to be Mississippi's next Attorney General?
I think it would really be a series of experiences. As was mentioned briefly during my introduction, I had the privilege of serving as Chief of Staff and Counsel to Governor Kirk Fordyce when we ramped up the first Republican administration in the modern era. And those of you who remember Governor Fordyce know that he had need for legal counsel quite frequently for a variety of different reasons. So that was a refreshing and invigorating and challenging opportunity to, first of all, learn more about the practice of law in the public arena, but to perform one of the key functions of the Attorney General, which is to represent the state's top officials. That is the job of the Attorney General on an ongoing basis, as well as the state as a legal entity. But in addition to that, Russ, it was my privilege to be retained by Governor Haley Barbour, later when he was governor, to represent the people of Mississippi, arguing the voter ID litigation before the Fifth Circuit Court of Appeals down in New Orleans. Governor Barbour could have hired any number of lawyers to perform that function, but he asked me to do it. And again, that is one of the roles of the Attorney General, representing the governor before federal courts on matters of import to the people of Mississippi. And then thirdly, as was briefly mentioned, when Governor Phil Bryant was still state auditor, many of you will recall we had the very unfortunate case arising out of the WorldCom tax debacle. And part of that involved the need to recover about $6 million in illegal attorney's fees that had been paid. And State Auditor Phil Bryant hired me as his attorney, again, a role that ought by right to have been filled by the Attorney General, but the Attorney General wouldn't do it. And then most recently, in the aftermath of the awful Department of Corrections scandal, which resulted in our corrections commissioner stealing $1 million that we know about, not counting what we don't know about, Governor Phil Bryant asked me to co-chair the task force to make recommendations to him and to the legislature about how we could revise our statutory scheme to try to keep that sort of mess from happening again. And again, that is a function of the Attorney General. So I think what I would say, really my answer to the question is a series of having been retained to perform the role of the Attorney General in circumstances where the Attorney General would not do it, have prepared me very well actually to do the job.
Thank you. And to you, Representative Baker, what experience, personal or professional, do you cite that best qualifies you to be Mississippi's next Attorney General?
Honestly, I believe that my entire adult life experience qualifies me to serve best as the Attorney General. 32 years of active practice of law, trying cases in state and federal courts all over the state, appeals to all levels of courts. Before I got elected to the legislature, I actually represented the state, many of the state agencies under tort claim cases, terrible accidents, car wrecks, train wrecks, you name it. I was involved in very complex litigation representing the state of Mississippi. But more so, in my 16 years in the legislature, I have seen the office of the Attorney General. I know how the office of the Attorney General is holding the state of Mississippi back. Case in point, when we're talking about tort reform in 2004, Mr. Taggart talks about the things that he was doing to represent the state of Mississippi. I was in the trenches with the state of Mississippi passing the legislation that ultimately was voter ID or tort reform or whatnot. When we were fighting tort reform, we were fighting General Hood then. When I became chairman of the Judiciary Aid Committee and I passed Sunshine so we could finally get a handle on the 100 and so no bid, no lose contingency contracts that our Attorney General had issued out and given lawyers over $110 million that was not appropriated by the Mississippi legislature so outside counsel could buy bigger mansions and faster jets, money that should have gone into the general fund to educate our children and fix our roads and bridges. I was there when we were trying to make that fight, and so I understand the policy is made by the politics in the Attorney General's office. And I have a 16-year record with regard to politics in relation to policy. And so if someone asks, you know, President Reagan used to say trust but verify. With me, you go straight to verify. It's all on the record. 100% record for protection for the rights of the unborn, 100% record on religious freedoms, 100% record on Second Amendment issues, 100% record when it comes to fiscal responsibility. These things are important when you're dealing with the Attorney General's office. Because in our day and time, if you had a map of the United States and you went from right to left, you would see that legislatures have gone from blue to red. The president's Republican, conservative, we've got the Senate, lost the House, we'll get that back. And so it's the day that we live in that legislation is being performed through litigation. And so we need an Attorney General who has the experience and the proven record to fight these fights in the courts when they come up. There's going to be a lot of issues we talk about today. General Hood has dropped the ball. He was AWOL on the fetal heartbeat bill. He didn't even go to the hearing 2 weeks ago. And we need an Attorney General who has a proven record of fighting. And I will tell you this, in 16 years in the legislature, the heavy lifts came to my committee. And we'll talk about those in a little bit more.
The next question starts with you, Representative Baker. What would be your office's primary focus during your first term, civil or criminal?
My office's primary focus during the first term would to get the department, the agency ready to fight the fights like the heartbeat bill. They're not ready. They're not prepared. They're losing these fights. Like I was explaining to you, the Attorney General's office, the politics of the Attorney General's office is deciding which fights to fight and which fights to run from. And we need to have an office that is engaged and ready and willing and able to fight these fights. And that doesn't exist right now. During my first term, I can tell you that the lawyer that you pay for, that you elect, it's like a job interview. This is what we're doing. This is a job interview. The lawyer that you pay for and elect has to lead the office, 157 lawyers, 170 plus minus staff, and has to right the ship. The first thing that we've got to do from the standpoint of the civil side is we've got to cancel all these outside contingency contracts right now. The public policy is lost when you're giving a lawyer a contingency fee. There's no problem with the lawyer. I mean, that's what they do. They earn money, they earn fees. But the public policy aspect of that is lost by those contingency fees. Fewer lawsuits from the business side and public interest more concerned. I can remember when I was out campaigning, when I was the Republican leader from 2007 to 2011, I told the House, if you'll elect me Republican leader, I'll go around the state and I will find qualified candidates. And when we come back in 2012, after we had lost the speaker's race by 1 vote, we will have a Republican majority and we will elect a Republican speaker. When I was out campaigning for that, when I was going around the state raising money and finding good candidates, I came across an economic developer. And he was so proud about the fact that he was going to have a business come in town. And I said, sir, can you tell, I'm on Ways and Means, I'm going to be helping you with some bond issues if this comes up. Can you tell me who that is? Can we talk about it? And he did, and I said, well, they're not coming. And he looked at me like I was crazy. What are you? You don't know anything. What are you talking about? And I pulled out a list of lawsuits, and I said, see, on page 3 right there, our Attorney General is suing that company. And I don't know much about CEOs, but I know this. CEOs don't come where they're not wanted. So what we have got to do is we have got to lead this office back to lawyering, back to protecting the public interest, back to working with law enforcement. Mr. Taggart talked about the scourge of drugs. Opioid crisis will not be fixed until we begin to partner with the federal, state, and local agencies, and the Attorney General has got to lead the way.
Okay, thank you. To you, Mr. Taggart, what would be your office's focus during your first term?
Well, I'll tell you, it would not be on the civil side, as important as that is. It would be on the criminal side. Many of you know my wife's and my personal story. We lost our youngest son to suicide after a year of illicit drug use about 7 years ago. And that has caused us to be very steely-eyed in our resolve to try our best to help the entire state understand that the gravest danger faced by our families and our communities is not somebody who is selling school milk to the local school district or what search algorithm Google has on its search engine. It is the scourge of drugs. It is the poison that is causing, if we were candid with one another, folks, it is the poison that is causing every single family in every single one of our communities to be at risk in some way or another. And virtually every one of our families, if candid, would acknowledge that we've been touched by this scourge in some way. My beef with the Attorney General is not because we're running against him. We're not. As you know, he's running for another office. My beef with the Attorney General is that he has not configured the resources of the chief law enforcement official of the state in a way to fight what I believe to be the most important fight that ought to be fought on behalf of the people of Mississippi, and that is against this issue of drugs. Now, opioids are a legit issue, and we're going to have to deal with that, and we've got to be much smarter on the regulatory side than we have been. But the gravest danger that we face is illicit drugs, and we need to focus our resources on dealing with that issue, acknowledging the difference between predators on the one hand and victims on the other, figuring out ways to redeem and rehabilitate and restore victims back to contributing members of our communities, and nailing the predators to the wall. But the only way we're going to be able to do that is when we devote sufficient resources to doing it, to provide support for our local police departments, support for our county sheriff's departments, and at the state level to be very steely-eyed in the determination that this is the fight to which we are going to devote the resources of the people of Mississippi.
Thank you. All right, the next question begins with you, Mr. Taggart. As Attorney General, what steps would you take to protect religious liberties?
Well, first of all, it rings home very much for me because it's an important part of Karen's and mine, our family's lives. We have tried to live out our private lives in the way that we conduct ourselves in public and in the manner in which we develop public policy. Fortunately, in our state, by and large, religious freedoms are acknowledged and valued and protected sort of in the community at large. And the legislature, tip of the hat to them, have done a good job in making sure that that's also reflected in state policy from a legislative standpoint. But I think what I would say is that when you have standing behind you the very power of the First Amendment of the Constitution itself, which guarantees religious liberties and forbids the government from infringing on anyone's exercise of their religious liberties, that you almost always have the moral high ground when you go to work for people in the protection of their religious liberties. I believe what we need is an Attorney General who is not willing to be shouted down for political reasons on the premise that, for some reason that this might not be a politically popular posture for him or her to take. And regrettably, we have seen that to be the case. I completely agree with Representative Baker on that point, that political decisions have affected far too much the policy positions taken by our Attorney General. But for heaven's sakes, I'm not going to have any difficulty at all in standing strong for the First Amendment or strong in defense of the statutory framework that the legislature has adopted to help protect the First Amendment.
Okay, thank you. Same question to you, Representative Baker.
Thank you. I was proud to vote for 1523, which was the Religious Liberties Bill. It's an important law which clearly defines and protects individuals, religious organizations, and businesses from having to check their religious beliefs at the door to engage or to involve themselves with things that may or may not be regulated by the state. So let's be clear. It's important in this respect, and let me tell you, remember when I was talking about the change in the country, blue to red, talking about legislation being litigated in courts, and that's where it's happening now? So 3 weeks ago, the Michigan Attorney General, with a stroke of a pen, vitiated a state law that permitted religious organizations like Catholic Charities and Bethany, where they didn't have to check their religious beliefs at the door when they engaged in adoption and foster care services. The Michigan Attorney General said, no, we're going to settle that ACLU lawsuit, and now you religious organizations, if you're going to engage in adoption and foster care services in Michigan, you're going to have to check your religious beliefs at the door. Never mind the fact that there were non-religious organizations that were engaged in the forum. Why is that important? Mississippi has just such a law. In fact, it has two, and I voted for both of them. We have to make sure that we have an Attorney General that has a proven record on this and will stand up and say, no, we're not going to make religious organizations check their religious beliefs at the door for them to engage in such services in the state of Mississippi. These are vital services that are important to our citizenry. And I just think that we just need to have an Attorney General that has a proven record, that will stand up And I have that record in the legislature, and I will stand up for religious liberties as the Attorney General.
All right. Our fourth question comes from another question from William Carey University students. What steps will you take to ensure free speech on campuses at Mississippi State colleges? This one's to you, Representative Baker.
Well, this is the new thing. This is the new thing when the speech being expressed, generally in this case of late, is conservative speech that's attempting to be expressed, then the administration that has a different political view is finding ways to create obstacles in the way of the expression of that speech. There's very clear case law in this regard. The Supreme Court has written opinion after opinion after opinion. And so what we need to do is to make sure that colleges and universities understand that the creation of these limited free speech zones on campus and eliminating other public areas, public accessible areas, is wrong and will be fought. College administrators need to also understand that shielding students from speech that they may not like or find uncomfortable is not proper and is not acceptable, and it won't be tolerated. In fact, speech has to have protection and should be expressed. And so there's also the element that we need to make sure that when this speech is expressed on college campuses, that those that are expressing the speech have adequate protections to engage in that process. And that there are actions involved and created for those that would interfere with the free exercise of speech. It's a never-ending cycle. It happens, and right now, like I said, the oppressed or the conservatives that are trying to express speech freely on college campuses, campuses are entitled to reasonable time, place, and manner restrictions. Beyond that, content restrictions are very problematic and almost always will not survive the strict scrutiny test. And so as the Attorney General, we need to make sure that college campuses understand that and make sure that the opportunity for the free expression of speech occurs and continues on those college campuses.
Thank you. To you, Mr. Taggart.
I would say a couple of things about this. First of all, Representative Baker hit on a couple of really important constitutional premises arising out of the First Amendment again. Again, the First Amendment here is on the side, of course, on the exercise of free speech. There are two other important premises there. One of them is that prior restraint, saying ahead of time, you can't say what I think you're about to say, is just not allowed under American jurisprudence. It violates the First Amendment. And of course, our public universities, at least in our public colleges and community colleges, are public marketplaces. Private schools can make the judgments that they want to. Public universities are public marketplaces of ideas. And so the First Amendment directly applies to the policies that may be implemented on our public university campuses. Prior restraint simply is not allowed. It's against the law. Secondly, the idea that the exercise of First Amendment rights somehow ought not to ruffle anybody's feathers or somehow be offensive to people or cause people to trigger or cause people to feel as if they're not in a safe zone. Ladies and gentlemen, that's why we have the First Amendment. The First Amendment is not designed to allow me to say things that make you happy all the time. We have the First Amendment so that I can say things that might in fact be offensive, that might be unsatisfactory to King George, right? That's why we had a revolution. It's because it was illegal to say things bad about the king. You get your head chopped off. But in our country, we say, I can in fact say things that might raise your temper. Now, another constitutional premise is, if I am doing something that creates a clear and present danger, an actual danger, then of course I can be stood down. But I think the simple, easiest way to answer this question is, if the Attorney General got word that a speaker from whatever political stripe, on wherever in the philosophical spectrum he or she might fall, was about to be told that he or she could not address a group on a public university campus, I think the right thing to do is for the Attorney General to pick up the phone and talk to the chancellor or the president or the provost of that school and say, we just can't do business that way. You cannot tell people that they cannot exercise their First Amendment rights just because the ABC Club is going to be offended as a consequence of it.
All right, our fifth question is another William Carey University student question, and it starts with you, Mr. Taggart. What will you do to ensure equal opportunity for all Mississippi residents, regardless of race, sex, or marital status?
Well, I think my answer would be enforce the law, because the law guarantees that people be equally treated, notwithstanding each of those characteristics. The manner in which we do business in the United States is that we say that whatever your characteristic quality might be, and whatever your religious belief might be, whatever your national creed might be, and whatever your ethnicity might be, are not factors that may be held against you in the manner in which we do business in this country. And thank the Lord that that is the truth. For all of the challenges that we deal with on immigration policy, America is the world's melting pot, and the fact that we are the world's melting pot has been a hugely beneficial thing in the history of this nation. We have said to all the world that you can come here and have opportunity so long as you come here legally and so long as you comport with our laws. You may have opportunity here no matter what your religious tradition might be, no matter what the color of your skin, no matter your ethnicity. And if that ever comes to be threatened in the state of Mississippi, then as Attorney General, my job simply would be to enforce the law, to prevent people from being mistreated as a consequence of those characteristic qualities.
Thank you. Representative Baker?
I think that the Attorney General's office, again, this is an area that I think the office has been deficient and needs to be corrected. The Attorney General has a vast array of resources, lots of personnel, the ability to investigate and to provide these investigations to federal authorities. So let me give you an example. There are many federal laws where the Attorney General doesn't have the opportunity to file suit, but can work with the federal government. And then there are cases where the Attorney General, in fact, the State Attorney General in Title VII, ADA, fair housing, can actually file lawsuits on behalf of those that have been discriminated against. When you look back in the annals of the Attorney General's annual reports that are filed, you won't see any references to that. You won't see any bureaus or organizations or any type of personnel that's dedicated to helping those that have been victims of discrimination work through the system where the Attorney General may not be able to file a suit, but may be able to refer information to the federal government, to the U.S. Attorney's Office, something like that. And so the Attorney General can be much more proactive when it comes to enforcing the laws that the federal government should enforce, and comes to enforcing those federal laws where the Attorney General can in fact pursue those and move forward with those.
And so, just let me ask a follow-up to both of you. I mean, is it your sense right now that there are current equal protection or equal opportunity issues that maybe aren't being enforced by the Attorney General's office? And we'll start with you, Mr. Taggart.
I can't tell you that I'm aware of any off the top of my head. I can tell you that in agreement with the point that Representative Baker made earlier, I do believe that there is a general willingness to allow for pushback on conservative speech and conservative speakers that has been arrived at on the basis of political considerations and not on legal considerations. But with that exception, I can't tell you that I can think of specific equal opportunity issues that I think have gone lacking.
Same question to you, same follow-up question to you, Representative Baker.
I think it's just a general malaise in the office. I mean, when you have an Attorney General that's basically moved away from the Capitol, and you have the office that is basically on autopilot, many of these issues and many of the problems that we're talking about rise to the top. And so as much dedication and time as our Attorney General's office seems to spend suing businesses should be rededicated to interdicting drugs and protecting those who are victims of discrimination, and working on issues with regard to cooperating with law enforcement, working on illegal immigration with the Trump administration. I mean, it's just, there's no focus. And this election gives us an opportunity to bring focus to this office. And this election gives us an opportunity to bring a conservative focus to this office. And it's important that we do so.
Okay, thank you. All right, turning to question 6, this is another William Carey University student question. Is there any proposed or existing Mississippi law that you would not defend if challenged? If so, how would you handle that task? To you, Representative Baker.
You know, I was thinking about that question. I've been in the legislature for 16 years, and I probably voted on all the ones that we passed. So,
Not ones you don't like, but ones you can't defend.
so I'm going to say no. You know, there's a lot of laws in the law book, so it's an open question. I started thinking, well, surely there's something there. But you know, the Attorney General's job is to defend the enactments by the legislature. I mean, that's the function of the job. If the state of Mississippi is sued, passage of law, the Attorney General's job is to step up and defend that. I would kind of turn it and say there are things that I would step forward and defend that I feel like the Attorney General's office is failing to do. The heartbeat bill comes to mind. I do believe that the Attorney General's office should have stepped up and should have fought that, and certainly the Attorney General should have shown up. I think if you look at some of the things where the federal government has come and tried to impose its will on the state of Mississippi, the Attorney General should have been much more aggressive in fighting those issues. And let me give you a case in point, Obamacare. People forget that there was a personal mandate, but there was also a mandate to the states, where the states were going to be compelled to expand the Medicaid program under ACA. That expansion would have cost the state of Mississippi, conservatively estimated, $1.5 billion. It would have taken every bit of growth. It would have required tax increase. It was a mess. 44 attorney generals from around the country joined in litigation against that law, against the implementation of that law, and our attorney general was AWOL, nowhere to be found, didn't fight the state mandate, did not fight the personal mandate. It's just instance after instance. And so from my standpoint, it's a turnaround. We're soon going to be, we've now gotten a letter from the Humanist Society. The Humanist Society says you're going to have to remove "In God We Trust" from the car tag or provide an alternate, or we're going to sue you. Well, come sue us. I voted to put "In God We Trust" on the state motto, and you know what? In Mississippi, in God we do trust. It's on our money, it's on our motto, and if the Humanist Society wants to file suit, let them come on. I just see that we've got to turn that a little bit. The state flag has become an issue. Now suddenly we've got it we're talking about usurping the decision of the electorate through an election and asking for politicians in Jackson to change that, to nullify that election. And so there are a myriad of things that have to occur in this case, and I'm just, you know, in that regard, I think we need to hold tight and defend the laws that we pass.
Thank you. And same question to you.
I think the question was any proposed or existing law that I would not be willing to defend in court. Well, I can't answer it as to proposed laws. I don't know what ideas somebody might have out there, but as to existing laws,
there are a lot of bad ones.
No question about that, and there are a lot of bad laws too. But you made a good parenthetical a few moments ago. It's not just laws you don't like. It's any that you would not defend. Well. Even more strongly than Representative Baker made the point, there's a statutory mandate that the Attorney General come in and defend any statute of the state of Mississippi when its constitutionality has been challenged in court. So there is an instruction. The law says the Attorney General shall do this. Well, there are recent examples of cases in which the Attorney General simply hasn't, because he just has decided, I suppose, in his judgment that the legislature did a bad job with the law, and so he's not going to defend it, and policymakers have had to make other arrangements to get counsel to defend existing Mississippi statutes. For one thing, that's completely unconscionable. In my mind, the only time the Attorney General could ever defend having reached that conclusion, and I can't imagine getting there myself, but the only way he could ever do it is to say that it would have violated his oath either as a lawyer or as Attorney General for him to have defended such a statute. Well, it's almost incomprehensible for me to think of such a circumstance, and in any event, what I can tell you is I know of no existing Mississippi law that I would not vigorously defend on behalf of the people of Mississippi if it were challenged from a constitutional standpoint. And I got to tell you, I really share Representative Baker's pique about what the Attorney General just did on the heartbeat bill. He doesn't show up at all in the court hearing. The court hearing goes against the state of Mississippi, and then the Attorney General raises his hand and says, well, I'll appeal it. Well, thank you very much. Where were you yesterday is where I want to know.
And so, asking a follow-up question, starting with you, Representative Baker. I mean, you guys seem to be of the same mind on this issue. I mean, recently in the last few years, the Attorney General's office in D.C. at the Department of Justice, for instance, has maybe fail to follow through and protect federal statutes. And it's y'all's view here that y'all would pass the laws or defend the laws as passed, and that you would defend them wherever they're challenged. Is that your position? Do you, Representative Baker?
Absolutely. I mean, that's why I'm running for the job.
Okay. And do you, Mr. Taggart?
Yes, including the laws that I might disagree with or think were ill-advised at the time.
Well, that's a good separations of powers questions for us Federalist Society people, so thank you. All right, the next question is question 7. What is the appropriate relationship between the Attorney General's office and the Governor's office? As you know, we've almost had a counter office or counter administration, and now we're going to be having our first new Attorney General, and we wanted to find out how you think you'd handle conflicts and handle the relationship with the Attorney General's office, with the Governor's office, knowing in fact that you may or may not be of the same party as you. This one starts off with you, Mr. Taggart.
Both officials are constitutional officials, and both are elected statewide. The governor is the chief executive officer of the state, and the Attorney General is the chief legal officer of the state. What you would like to think is that the Attorney General actually could be the governor's lawyer. I don't think I'm looking through the world in completely rose-colored glasses. That's the way it's supposed to work, right? The governor is supposed to be the person who is leading the state and representing the client, and the Attorney General is supposed to be the lawyer representing his or her client's interest. My judgment is that it's been a very long time since that's the way the system worked, if it has ever worked that way. When I was in Governor Fordyce's office, it certainly didn't work that way. We were fighting with the Attorney General's office all the time. I perfectly well know from personal experience that Governor Barbour was often on the wrong side of the Attorney General, and the Attorney General was fighting the initiatives that Governor Barbour was trying. And when I was representing State Auditor Phil Bryant, we drafted a complaint, and I will tell you, the lawyers in the room will get a chill at this, but I'm telling you it is absolutely the truth, and it's documented on paper. We drafted a complaint for the state auditor to bring suit to recover these illegal attorney's fees, tendered it to the Attorney General, our current Attorney General, as the lawyer for the state of Mississippi, and as the governor was really required to do, tendered to him, General, we want you to file this on behalf of the Office of State Auditor. Not only did the Attorney General refuse to file that lawsuit, he fires off a copy of the draft complaint to Mike Moore, who then sends it to the defendant that the state auditor was about to sue. So the defendant runs up to bankruptcy court in New York City and brings his own lawsuit before the state auditor can pursue his claim. Ultimately, we ended up winning that at the end of the day before the Mississippi Supreme Court, but it cost an additional huge amount of money and a very great period of time, not because the Attorney General disagreed with the governor. The Attorney General very well could have said, Governor, I'm not able to represent you in that matter. You'll need to retain other counsel. But he went far beyond that and actually divulged to the adverse party the intention of the person that was supposed to be the client of the Attorney General. Excuse me, as you can tell, I'm still a little bit exercised about that. And so my answer is the Attorney General and the governor ought to work hand in hand. Of course there will be times when they will have policy disagreements. So long as they're only policy disagreements, the Attorney General still owes the duty to represent his client's interest. Only when their legal beliefs, their legal strategies, their legal ideologies diverge should there be a time that the Attorney General has to say to the governor, you'll need to retain your own counsel.
Thank you. Same question to you, Mr. Representative Baker.
The issue is the Attorney General the governor's lawyer, or is he the people's lawyer? The Attorney General is the people's lawyer. He is vested with the authority to represent the state of Mississippi, the 22 executive agencies. He's got MOUs with 80 other agencies, and the governor's office is one of his representation obligations. Having said that, you want to, in a perfect world, as Mr. Taggart indicated, you want to try to represent your governor, right? You want to try to do that. It's not worked. It hasn't worked for some time, and that's why the politics of this office are so important. you're going to get into a situation where you just simply disagree. And if the governor wants you to pursue that lawsuit as the Attorney General, you're just going to have to look at him and say, I just disagree. I'm not going to do that. You're going to have to retain your own counsel. The default should be to do so, but it's not going to work that way. It just hasn't worked that way. It's not going to work that way. When the governor's sued in his official capacity, absolutely, you're there, you represent, you do all the work. It's when the governor decides to be proactive in lawsuits where you're going to get this divergence of issues and views. That's why it's critical that you know the politics of your Attorney General. I stress that time and time again, but we've learned from our current Attorney General that we know his politics, so we know where he's going to come down. Of course, Mr. Taggart remembers that, in fact, the reason that he'd done all that is because he had already given the $6 million in fees to the lawyer at the time. And so he didn't want to have to worry about having to go get that back. And, of course, the Supreme Court said you didn't pay it correctly. I don't know whatever happened to it, but I think the lawyer may still have it. But what I'm getting to the point is this. When you're in this position, it's a difficult area. Your default should be to do what you can to represent the interests of the governor when he asks you to do that. But that's not always going to work. It's not real life. It's not reality. It's not going to happen. And when that happens, you just need to be straight up and advise them and let them proceed accordingly.
Okay. And so to clarify, I guess, when you reach a point, you're both saying, I think, when you reach a point on an issue where there's litigation going on, and as we all know, that can be sort of intense, and you'll reach a point where your legal philosophies and strategies won't align. Are you saying, I guess, how would you judge that point where you allow them to go on?
It's pretty clear. When the Democrat leadership in the House was trying to force redistricting a year earlier, they knew we were going to win the majority in the House in 2012. When they tried to force redistricting a year earlier, the governor and General Hood were sued as defendants and took diametrically opposed positions to the litigation. It was just pretty straightforward. That happens time and time and time. We can give you example, chapter and verse, and it has happened. And we've had to deal with those issues, and so. You can see it in those instances. You can see it when it's not generally while you're in the course of representing the client that you suddenly have decided, oh, well, I can't do this anymore. You know the issues going into it. It's not a surprise, and they're generally political issues, and it's just your point of view, and it's whether your interests are aligned with the governor's interests, aligned with the interests of the people of the state of Mississippi. Same question to you, Mr. Taggart.
There actually is a Mississippi Supreme Court case that answers that question in the context of ongoing litigation. The Ethics Commission back in the mid-1980s wanted to sue a variety of different state officials who the Ethics Commission believed were violating the Separation of Powers Act. The then Attorney General, Ed Pittman, agreed with them as to some of the officials, but not as to others. So the Attorney General brings a lawsuit against A, B, C, and D, but not against E, F, and G. And the Ethics Commission said, no, we want to sue everybody. And the Attorney General said, well, I get to decide. I'm the Attorney General. We're only going to sue those four. The Ethics Commission goes to the Mississippi Supreme Court, and the Supreme Court says very much in response to your question, the way this is going to work is, if in the exercise of its constitutional or statutory authority, a state officer or a state agency believes that it must take a legal position that the Attorney General is either unable or unwilling to take, then the Attorney General must authorize that officer or agency to retain counsel of its own choosing.
And I have to ask one more follow-up question, because this convoluted situation has been going on in Mississippi for some time now, as I think you guys know, where you have the AG on one side and the governor on one side, and sometimes you never really know how it's going to go down. When you reach that point, early on where you're going to go your own way, will you stay out of it as Attorney General, or if he starts taking the case into a direction that you just philosophically think is illegal or whatever, the state's still a party in there, you're still the Attorney General, you sort of still have standing or authority to enter an appearance. How would you handle that? Representative Baker?
I'm not staying out of it. If I've gotten to this point where I've told the governor, hey, oh, by the way, I'm not going to do this, I'm in it. There's a reason I've done that.
You see how sticky it can get, right?
And there's a reason I've done that, and the fight is on. I'm in that fight. I'm not going to say, oh, I disagree with you, I'm going to walk away, because generally at that point, it has risen to the level where you have got to, this is something that's become critically important.
Same question to you, Mr. Taggart.
I completely agree with that. The statute that authorizes the Attorney General to and commands that he come in and defend the constitutionality of any statute when it's threatened also requires that the Attorney General be the person that is in charge of the management of litigation on behalf of the state. So in the case, for example, of the litigation that I was describing a moment ago, the Ethics Commission pursued its theory of the case, and the Attorney General pursued his theory of the case in the same litigation. And you'd like for that scenario not to be repeated, but it's very likely that it's going to be repeated sooner or later. And in circumstances such as that, if I believe that the best interests of the state of Mississippi required me to take a position that was contrary to a position being taken by another officer or another state agency, then I would still be duty-bound to take that position and to pursue that litigation with vigor.
Shifting gears to our next substantive topic. This is something we've touched on before, but we're going to ask specifically here. Under what circumstances do you believe it is appropriate to hire outside counsel, and will you use the competitive process to do so? Starting with you, Representative Baker.
Well, outside counsel is a tricky situation, and I've been very clear in my position with regard to contingency contracts. I'm not a fan of them. I don't believe in them. I think they're absolutely contrary to the public interest. And so there is not an instance where I would want to, or I would agree to, or authorize. Let me tell you, we put in the law in Sunshine that said, before you can do this contingency contract, Mr. Attorney General, you have to say in writing that you and your office lack the skill and the ability to do the work. I got to tell you, no lawyer worth his salt ought to sign that contract. and I put it in there specifically in the law because I couldn't imagine anyone would. And he has signed them to a fare thee well. So there's absolutely no way. I see no scenario where contingency contracts. Now, hourly work is an entirely different animal. And there are cases where you will, and there are things that are within the Attorney General's purview, like child support collection and tort claims and workers' comp. There are other claims that occur that you may hire that out on an hourly basis. That's the prevailing bar rate. That's what's in the law, things like that. But really, you know, here's the thing. The Attorney General's office, we talked about 157 lawyers. We talked about 170 staff. Those are authorized pins. There are actually 40 vacancies there, plus or minus. The Attorney General's office is just kind of dying on the vine. What we need to do is we need to have somebody who has a relationship with the legislature, can work with the legislature, build this office back up, and bring this work in-house. I mean, this is lawyer work. This is work that we can do. We can save the state money. We need somebody that knows how to do the lawyering and knows how to run a law firm. And that's just kind of where we are right now. But respectfully, there's not an instance that I can imagine that I would do a contingency contract. No.
Same question to you, Mr. Taggart.
I believe the starting position on any litigation ought to be that the Attorney General and his or her staff is going to manage the litigation. That ought to be the starting position. It ought to be the default position. The Attorney General then ought to perform his own analysis. Is this a matter that is of sufficient import? That is to say, is it important enough for me to even go through this analysis? Secondly, is it of sufficient complexity? Is the scope broad enough? Are the stakes high enough that in good conscience, either it would just tap the resources of this office too greatly, or in all good conscience, and occasionally it will be the case, I just don't have the expertise at my disposal to manage this thing. Only then, in my estimation, should the Attorney General consider the retention of outside counsel, and in that event, it should be by some sort of professional review process, such as the question implies. I use the acronym RFP for request for proposal. Some say RFQ for request for qualifications. There are a number of ways that professional firms, not just law firms, but CPA firms and accounting firms and architectural firms and engineering firms, there are a number of ways that a competitive component can be brought to the table and still result in the retention of very, very high quality professional services. The manner in which, for example, Governor Fordyce brought that to bear was he required
request for proposals and request for qualifications for bond counsel. Well, you talk about sending a shiver down the backs of an awful lot of people making an awful lot of money on municipal bond issues back in the early 1990s. But you know what? All of a sudden, bond issues didn't cost $500,000 to get issued in professional fees. Sometimes they cost $50,000. One time they cost $10,000. Now, does that mean we were getting sorry service? No, we were getting served by the same law firms. All of a sudden, it just didn't cost as much. Why? Competition. Boy, what an interesting idea. In addition to which, I got to tell you, it just rankles me at the thought that, Representative Baker, and I suspect you as well, that there just don't seem to be enough competent lawyers in the state of Mississippi to perform the services when the Attorney General does need outside counsel. So he has to go to New York City or Chicago or Dallas or Atlanta to find lawyers that are good enough to represent us here in the state of Mississippi. Well, I just kind of disagree with that premise. There are plenty of very, very fine lawyers, many of whom have beaten up all up on me in courtrooms during the course of my career, who practice law right here in the state of Mississippi. Default position ought to be, we're going to do it here in our office. Second question ought to be, is this even important enough for me to consider whether I ought to think about hiring private counsel? And if the answer to that is yes, we're going to do it in a competitive way.
All right. I'm going to ask you one more question, and then we'll have 3 minutes each. Closing statements. This is a question that has often divides and makes strange coalitions between people with different philosophical views. But the question is related to civil asset forfeitures in the criminal context. Mr. Taggart, how would your office, how would you as Attorney General either maintain or change or enforce the civil asset forfeiture laws?
Well, I'll tell you, that's probably an area in which Mr. Baker and I have a significant disagreement. First of all, I think I would say that on a day-to-day basis, that's really not an issue that would be dealt with by the Attorney General's office unless the Attorney General was prosecuting a matter locally. But it's regularly an issue for local prosecutors, and it arises regularly. The laws that are in place are what they are. As Representative Baker knows, there was a big set to about whether to revive the administrative forfeiture laws in this last round of the legislature, and they ended up not coming to a vote because of significant opposition. And then the next layer is this issue of civil asset forfeiture. I must tell you, I find it philosophically difficult to be satisfied with the notion that a person that is subject to criminal prosecution ought to have his or her stuff taken in the process of determining whether he or she has actually committed a crime. It's very difficult for me to think as a lawyer how that doesn't violate the premise that everybody is innocent until proven guilty. Now, clearly there are going to be circumstances, and there are all kinds of stories about, well, there was $50,000 in tinfoil wrapped up in the glove box, so nobody has $50,000 in tinfoil wrapped up in the glove box, so we ought to take that. Well, probably so. But what if it was $5,000 wrapped up in the glove box, and it was Mr. James who was coming to buy my 2006 Chevy pickup, and when he drove it for a test drive, he brought it back to me and said, well, it's not perfect, but I think it'll do. And Mr. James pulled an envelope with 50 $100 bills out of his pocket, and he started counting them out on my kitchen table. I said, Mr. James, you don't need, if you tell me that's $5,000, no, it was very important to him that he count out that $5,000. Now suppose that Mr. James had his nephew in my truck when he took the test drive, and his nephew had contraband, and his nephew got busted and should have gotten busted and got in trouble and should have gotten in trouble. And Mr. James and his $5,000, which somebody might have thought was involved in some drug deal that he had scrimped and saved for to buy my 2006 pickup truck, got seized. There's something just fundamentally wrong about that.
Thank you, Mr. Taggart. Representative Baker?
As chairman of the Judiciary Committee, I chaired the Civil Asset Forfeiture Task Force two summers ago. We brought interested parties from all across the spectrum to come in and express their position with regard to civil asset forfeiture. We had law enforcement, we had defense attorneys, we had ACLU, we had AFP, you were charged in the task force with looking at several things, whether or not looking at the matter of due process, looking at the matter of transparency, looking at whether or not there was sufficient protection for innocent owners. And we came up with recommendations of the task force, and we looked at several things to engage this issue. For example, due process. One of the questions was, is somebody, an impartial magistrate, looking at the matter of an asset seizure early enough in the process? And we created a 72-hour seizure warrant that said if a police officer stopped and got Mr. James's truck, that within 72 hours he had to present the facts and circumstances, the same warrant sufficient to make an arrest, same warrant to go into one's home, the sufficient facts and circumstances, present that to a judge and actually obtain a civil seizure warrant. That was the first thing. The second thing that we did was there was a question about with regard to transparency. Is there transparency? How much forfeiture is occurring? Where is it occurring? How is it occurring? And we created a 24/7 website where all of the dispositive matters with regard to asset forfeiture were uploaded to the website. Every bit of it, the initial seizure, the orders, the petitions, the whole 9 yards, the settlements, the resolutions, they're all right there. The third thing is we looked at the protection of innocent owners, and a couple ways we addressed that was to make sure that just anybody couldn't prosecute an asset forfeiture. So we left that with the discretion, with the authority of the district attorney and the Mississippi Bureau of Narcotics. And all of these things, when we passed civil asset forfeiture, included administrative forfeiture at the time, which is a lower dollar amount in the way you do the process. All of that was held throughout those party interests throughout the country, throughout those groups and whatnot that were looking at it as some of the most advanced civil asset forfeiture reform in the country at that time. And so we did a lot of work. We passed that with bipartisan support in the House and the Senate. So our civil asset forfeiture laws are in place to move forward. I mean, we hear stories like this, and I will tell you anecdotally, the stories we heard. I gathered every petition and every order of every active forfeiture that was occurring in the state of Mississippi and handed them out. We had a stack of them. Handed those out to all of the task force members, everybody that was involved, and said, find us the instances that we're hearing about where innocent owners find these things and find these things, just so we could make sure that we were adding and including the sufficient protections. As Attorney General, as Mr. Taggart said, the role with regard to asset forfeiture is different because it's handled by the MDN and it's handled by the district attorneys now, and it's initiated by the local law enforcement. My job would be to ensure proper training for law enforcement, for district attorneys, to make sure that the forfeitures are complying with the law, to make sure that they have the information that they know, to make sure that we're working through the steps in that regard. You may have heard recently the city of Jackson was not uploading, didn't have their information with regard to asset forfeitures on the website. Completely unacceptable, required by the law. As the Attorney General, we would make sure that law enforcement agencies are aware of what's going on and compel them to comply with the law.
All right. Okay, so now we've reached the point in the forum where we're going to have final statements from each candidate. Representative Baker went first in the opening statement, so Mr. Taggart will go first in the closing. They each have 3 minutes.
All right, if I stand?
Sure, of course.
As I said when I started, I believe that I am best prepared to represent the people of Mississippi as your Attorney General, for Chief Law Enforcement Official, and for top lawyer, but also as a person to help cast the vision for our future. In my estimation, not just state officials, but all elected officials ought to be talking to taxpayers and voters about what they think about the future. Looking forward, regrettably, it's just a fact, we've been obsessed with our past in the state of Mississippi. But I really believe there's a reason that windshields are so much bigger than rearview mirrors in our trucks. And that's because we spend a whole lot more time looking forwards at 60 miles an hour than we do looking backwards. And it ought to be the same way in the manner in which we think about what are we doing with state policy? Where are we going with the state of Mississippi? How are we making this a place that our young people can be enthused about choosing to stay and make their lives and build their livelihoods and build their families? In my estimation, what that really comes down to is, are we thinking more about the future than we are about our past? Should our past instruct us? Of course it should, just as surely as it should in our own individual lives. But it should not bind us. We need to be set free from our past and look to our future. And I will tell you, if you disagree with me on this premise, then I'm probably just not going to be your guy. If you disagree with me that tomorrow can be better than yesterday, If you don't think next year can be better than last year, then you're probably going to want to vote for somebody else. Because I'll tell you, in my vision of Mississippi, we can do better. The future can be brighter. We can give even more opportunity for our young people than our parents gave to us. And if that's your view of where we can go as a state of Mississippi, if that's where you want the state of Mississippi to go, I hope you'll give me the opportunity to serve as your Attorney General, because that's where I want to try to take us. Thank you so very much for being here this evening.
I've said this before, if you're looking for Jim Hood 2.0, I'm not your guy. I'm not your guy and never will be. I have served in the legislature for the past 16 years. It's been one of the greatest honors of my life. When Mr. Taggart talks about making policy to make Mississippi better, that's what I've done for 16 years. Made policy, enacted laws to make Mississippi better every step of the way. From the protection of the unborn to religious freedoms, from the Second Amendment to fiscal responsibility. In 2007, when I was elected Republican leader, we lost the speaker's race by 1 vote after 3 tie votes. And I told the Republicans in the House then, I said, if you will elect me leader, I will go around the state and I will find good candidates. We will take our message to the people. And when we come back in 2012, we will elect a Republican majority and we'll begin to move the state forward. I've never put my name on a ballot for anything other than the state representative until I decided to run for Attorney General. Because as I did when I was Republican leader, I looked at a problem. You know, in a world full of problems, be the solution, right? I looked at a problem and said, I can step up and I can fix this. As chairman of Judiciary A for the last 8 years, I have tried to reform the office of Attorney General. And I've come to the conclusion that you cannot reform this office from the outside in. You must reform it from the inside out. And so I put my name on the ballot to be Attorney General, much like I did when I was Republican leader, because this office needs to change. The entirety of state government is moving in one direction. The governor, the lieutenant governor, the legislature, Mississippi Development Authority, you name it, everybody's moving, trying to make Mississippi a better place. And this office is the outlier. It is holding Mississippi back, time and time and time again. You name the issue, this office is the problem. And so I stepped up to run to be your Attorney General because I believe that Mississippi can be better, but to be better, this office has to change. We've talked about the issues with regard to the lawsuit abuse. We've talked about that this Attorney General will not step up for conservative issues like the fetal heartbeat bill, will not step up for In God We Trust, things that are important to us. We've talked about these issues. Time and time and time again, this office has failed Mississippians. As I did when I ran for Republican leader, I'm stepping up to run for this office of Attorney General from the inside out. But to do that, you have to know the politics of your Attorney General. 16 years of on-the-record votes. It's all right there. Because when the lawsuit comes, and it's coming, you want to know that the Attorney General that you've hired is going to stand up and fight. And unlike our current Attorney General, he's not going to not show up. Thank you very much. I appreciate your vote and consideration on August the 6th.